Testing. Alright. Part 109, the problem with the transportation of hazardous material, the procedures and regulations. So part A, definition 109.1, definition. So part B, inspection investigation, opening packages, the room of the transportation examination, now the assistant properly qualified personnel with qualifying pass to save the presumption of the transportation 109.15, termination 109.16, the notification and enforcement measurements. And then subpart C, subpart C, emergencies order 109.17, emergency order 109.19, petition to review the emergency orders 109.21, remedies general, subpart D, equipment 109.25. 5, the equipment. Subpart E, prohibition has material operation, non-payment, the penalties 109.101, prohibition has material operations 109.103, note the non-payment penalties. Alright, so part A, definitions. The definition for the purpose of this involved all terms defined in Title 49 U.S. Standard Code of 5102, but they are the statutory meaning of the other terms of the the power of the define the following administrative meaning of the head of the aim of the operating train minister of the Department of Transportation, including the administrator of the Federal Aviation Administration, Federal Motor Carrier Safety Administration, Federal Railroad Administration, Pipeline Hazard Material Safety Administration, to whom the Secretary of the delegated authority and part of the one of the title of any person within operating an administrator of the to whom the minister of the delegated authority carry out this part. Agent of the Secretary agent means the federal officer employee of the agent authorized secretary of the inspection investigation of the federal hazard material transportation law, chief safety officer for the CSO means the assistant administrator of the pipeline hazard material safety administration emergency order means the emergency, the restriction, the prohibition, recall the out of service or set with it forth in writing for with container the means of the packet of the configuration reasonable and container that it has a value of the more cubic feet more design with control for the permit that is being lifted the with an intact container with the primary with the smaller packet if the unit is during the transportation immediately adjacent means the package of the direct contact with the hazard material with the otherwise preeminent means the containment of the hazard material. In a minute, with the hazard maintenance of the existence of the condition relating to the hazard material, the presence of the substantial likelihood of the death and serious illness, fears on the age of the substantial endangerment, health and property, the environmental may occur before the reasonable completion date of the formal proceeding before it becomes lessening of the risk of the death, the issue, illness, and the injury, of the endangerment. In writing means unless otherwise specified the written explanation for the action of the relay of the do this part, rendering the part paper the digital format delivered in person via the fast amount of commercial delivery to U.S. mail electronically. Objectable, reasonable, articulable belief means the belief made by the particular identifiable act of the provided objective base the belief the subsect of the package may contain the hazardous material. Out of service or order means a written requirement issued by the secretary designated the aircraft, vessel, the motor vehicle, the train, the rail car, the locomotive, the other vehicle, the transport unit, the transfer vehicle, the freight container, the portable tank, the other package of the time move or call the operation until the specific conditions have been met. Our packaging means the receptacle of any other component of the other material the receptacle, the performance, the contamination of the form, function of the performance of the minimum pack of the requirements of the subpart for this radioactive material package. You can see that 173.4 of the subpart C, the shaft of the reversible have the materials being the hazardous material, the subject of the significant risk of the speed, the decay, the deterioration, the spillage, spoilage, hazardous material, the cover the sign with the medical, the prevention of treatment of recur of the disease condition in human beings, animals with expeditious shipment. And delivered to me with a critical medical, the properly qualified personnel, means the partnership, the proprietorship of the individual is technically qualified to perform the designated have the necessary to inspect and examine the opening, remove the testing transportation packages. Related packages mean the package for the shipment, the group of the package for the can be detached for the common. The next is of the fact that included not limited to the same offer of the packaging the manufacturer same have the communication information parking labeling shipping documentation other reasonable articulable fact that may leave the agent believe the the package and relieve the package of the may of the imminent hazard packages are located with the same trailer and freight container of the unit and the load device of the package remove the subject enhanced authority with the additional fact that the substantial next is imminent hazard are not related to the package for the purpose of the removal of the related packages must also demonstrate that they may impose the imminent hazard they must exhibit the commonly nexus or origin which may they include but not limited to the common offer of the package of manufacturer marking label and shipping documentation have of the communications. Remove the means of the keep of the packet of the entry of the stream of the transportation convert for the take of the packet of the stream of the transportation convert for the physical detaining package off of the transportation convert for the stopping of the package for the continuing the transportation commerce. Safe expeditious means for the prudent measure for the perceived designated the minimum of the delay. Subpart B inspection investigation general authority administer the main issue the inspection of the investigation determine the compliance with the federal hazard material transportation law of the regulation order of the special permit approval to prescribe the issue of the federal hazard material transportation law of the court of the degree of the other order related to their relating thereto. Inspection investigations are conducted with the designated agents of the section secretary who will upon the request of the credential the examinations of the agent is authorized to do. Administrative officers will receive the affirmation for the aim of the material under the investigation, gather information for the aim of the reasonable means including but not limited to the game of the excess of the records of the property, including the package of the interview, photocopy, photographic, video, audio recording in a responsible manner, serve the purpose of the production of the documents and all other tangible evidence based on the information available to the agent, evidence of the relevant determination compliant with the Federal Hazardous Material Transportation Law regulation, other special permits on the approval of the prescribed issue of the Federal Hazardous Material Transportation Law, any court agree with the other relating thereto, the service of the being on the shelf of the requirements of the agent operating with this demonstration and operating administration set forth in Title 14 CFR 13.3 of the Federal Aviation Administrator, Title 49 CFR 209 Federal Railroad Administration, Title 49 105 45 105 55 Pipeline Hazardous Material Safety Administration. 109.5 the operating package. In general, the expected is provided with the paragraph B of the shop move of the package of the transportation, gather information for the name of the person, learn the nature of the contents of the package, opening over the package of the outer packaging, other component of the packaging that is not immediately adjacent to the hazardous material that contains the package, examine the inner packaging and package components, perishable hazardous material that ensure that expedition, transportation, packaging containing perishable hazardous material, the agent will utilize the appropriate alternative to the executive authority under the paragraph A of this section. Alright, 109, removal of the from transportation. Agent of the removal of the package related the package shipment of the freight contained with the transportation so for the up to 48 hours over the when the agent have the objective is reasonable, they are articulable with belief that the package may pose the imminent have the agent must record the belief of the writing as soon as the practicable to provide the written notification statement of the reason for the removal of the possession. 109.10.9 transportation examination and analysis. The agent direct package to the transported facility examination. They analyze the agent with the determination that the further examination package necessary to evaluate whether the package conforms to subpart C of the chapter. Information concerning the package exists. Additional investigation is not possible. Immediate premises. Event of determination conforms to paragraph A of the section. The agent may give the direct author with the package of the other reasonable person. Reasonable package if they have the package is transported to the facility where the material may examine and analyze. Driven the packaging manufacturer testing the packaging until they have the package is transported to the facility where the packaging may be tested according to the A hazardous material regulations. Direct the carrier of the transport package to the facility capable of conducting the examination and the 48-hour removal of the providing of the 109 may. Some of them may be the extent of the writing of the administrative pending with the collusion examination analysis under this section. Alright, 109.11. Assistant properly qualified personnel. Agent who may authorize properly qualified personnel simply require activity conducted in this part of the agent may not properly qualified to perform a function of the essential for the agent. The extra of the authority under this part of the site may otherwise be compromised for the agent performing such a function. Alright, 109.13. Close the package and safe resumption of the transportation. No imminent have the final if they have the agent extra for the authority under the 109.5 the agent at the time of the no imminent has the package otherwise conform with the applicable requirements of Part C of this chapter. The agent will, within preparing the package of the safe to promote the transportation practical to reclose the package according to the packaging manufacturer close with the instruction. Other public closures market the certified with the reclose with the package of the indicator that was open and reclose with the accordance with the part. Return the package to the person from who the agent obtained is as soon as practical for the package contained with the permissible to have the material as if the resuming the safe expedition transportation package soon as practical after determining the package presents no imminent hazards. Imminent hazard found if the imminent hazard is found with the existing under the agent exercise of the authority of the 109.5 the administrator that his or her designee may issue the out of the ordering the prohibiting the movement of the package until the package has been brought into the compliance with the subpart C of the chapter upon receiving the out of the order of the person in possession of the responsible for the package must remove the package of the transportation until the brought with the compliance. Packages do not contain the hazardous material if the agent does after the agent exercises the authority of 1 statute 109.5 the agent finds the package does not contain the hazardous material. The agent with the securely clothed with the package marked with the clear certified the clothed with the package with the identification was open the clothed with the return of the package of the transportation. Oh, non-compliant packages. If the agent with the extra of the authority of 195 the agent found the package contained with the hazardous material that does not conform with the requirements of subpart C of the chapter does not represent the amendment have the agent will return the package to the person in possession of the package at the time of the non-compliance discovered for the appropriate corrective action, and non-compliant packages may not be continued with the transportation until the identified the non-compliance issues are resolved. 109.15. The termination of the fact of the scope of the investigation indicated the further action not more to this part of the time of the administrator will close the investigation without prejudice to the further investigation. Notify the person being investigated of the decision notifying herein with regard to the civil enforcement action later time related to finding the investigation. 109.16. Notification and enforcement. In addition to the complying with the notification requirements of 109.7 the agent with the after the authority under the subpart immediately take the responsible measure to notify the officer with the person in possession of the package providing the reason of the action being taken with the result of the preliminary investigation, including apparent violations of Part C of the chapter. Any further action may be warranted. Alright, subpart C, emergency orders. 109.7 the emergency orders. Determination of the hazards with the administrator to determine the violation provisions. Federal hazardous materials transportation law of the regulation orders prescribing the law of the unsafe condition of the practice of the council of the causing of the imminent have defined in statute 109.1 the administrator may implement the emergency restriction prohibition, recall the out of service of the order of the advance note of the opportunity for the hearing the basic aim of the taken under the section shall be in separate forth them written within the month describe the violation condition for the practice of the council to the council causing the amendment have to set forth the terms and condition of the emergency order be limited to consent necessary to debate the amendment have the advice of the recipient of the list of the two calendar of the order of the issue of the recipient request to deliver review with the adding of the request formal hearing in accordance with Title 5 U.S. Code 554 must set for the material facts dispute give them right to the request of the hearing and set forth the following the interpret the requirement of statute 109.19 including the address of the Department of Transportation docket operations and all persons reserved in the petition review out of service the order of the out of service orders issued to prohibit the movement of the aircraft vessel motor of the vehicle train rail car locomotive the transportation vehicle other vehicle freight container portable tank and any other package until the specified conditions of the out of service order has been met. Upon the receipt of the out of service order, the person in the possession of the responsible for the package must remove the package of the transportation until brought with the compliance without the service order. A package subject to the out of service order may be removed from the place within the file with the president with the imminent have the nearest location where the package can be brought into compliance, provided that the agent who issued the out of service order is notified of the move. The recipient of the service order must notify the operating administrator that they issue the order when the package is brought within compliance. Upon the receipt of the out of service, the recipient may plead with the decision of issuing an order with the PHMSC chief officer of the position order review. The out of service order must be the requirement of 109.19. Recall: the PHMSA associated administrator of the office has the material safety issue of the emergency ordering operating immediately recall the packaging component of the container certified with the representative of the market for the sole qualified for the use of the transportation have the material of the commercial but conditions such for the items would be constituted and they have the petition to review the such emergency order of the government for the proceedings set forth in 109.19. 109.19 permission for the review of the emergency order. The petition of the review must be written state with a particular each part of the emergency order of the shop of the man with the reclaim with include the information evidence of the evidence of the support thereof state with a formal hearing in accordance with Title 5 U.S. Standard Code 554 with the request of the other sort of the material fact of the dispute given the requirement of the request of the hearing aid be filled in service in accordance with the statute 109.19F and be responsible to petition review the attorney designated with the office of the chief of the council operating administrator the issue of the emergency order of the main file of the service in accordance with 109.19F the responsible including property proceeding with 5 calendar days of the receipt of the petition of the chief of the council operating administrator the issuing of the emergency order chief safety officer responsible for hearing the request upon the request of the petition of the review of the emergency order of the include the formal hearing request of the safety material of the act of the dispute with the chief of safety officer shall immediately assign the petition of the officer for the hearing unless the chief safety officer issues the order stated the petition followed within the forward of the material fact of the dispute will decide on paragraph C2 of the section petition of the review of the include the formal hearing request of the deemed assigned with the officer for the hearing of the calendar days after the chief safety officer receives it. No hearing request for the petition of the review of the emergency order that does not include the formal hearing request that fails to state with the material of fact for the dispute of the chief safety officer shall admit if the administrative decision of the material merits within 30 days of the receipt of the position chief safety officer decision and constitute the final agency action. Hearings shall be conducted with the administrative law judge assigned by the chief of the administrative law judge for the office with the hearing of the administrative law judge may administer the open affirmations issue subopinions are provided with the appropriate agency regulation Title 49 CFR 209 something with the Title 49 CFR 10545 14 CFR 13.3 of the Title 49 from U.S. Standard Code 502 for 31 and 33. Adopt a relevant federal rule of the civil procedure of the United States, the District Court of the Procedures governing the hearing of the appropriate the relevant federal state rule of the evidence for the United States, the Court of the Magistrate for the submission of the evidence for the appropriate take the cause deposition of the take on the examine the witness for the hearing the rules of the proof the relevant the evidence convents recess adjourning otherwise regulate the court for the hearing hold come up as a settlement the simplification of the issues any other proper purpose take any other action authorized consistent with the provision of the permitted by law of the may expedite the hearing of the aid of the disposition issue grade therein party of the petitioner may appear with the be heard with the person by or authorizes the representative of the operating administrative issue for the emergency or shall be represented with the attorney and designated with the respective office of the chief of council following interpret each of the position pleading with the motion for the notice of the order of the document submitted with the connection with an order issued the support must be filed commercially delivered submitted electronically with the U.S. Department of Transportation document M30 with the west building ground floor W12 140 1200 New Jersey Avenue Southeast Washington DC 20590 with all documents filed with the public Department of the Document Management website with the Regulations Act of the emergency of the order shelves above the right filling of the right requirements of the address of the Department of Transportation docket operations for the eve the document filed according to the paragraph F1 with this section will be concurrently served upon the following persons chief of safety officer officers, the chief of safety, PHE, pipeline hazard material safety administrator, U.S. Department of Transportation, 1200 New Jersey Avenue, southeast of the East Building, Washington, D.C. 20590. Fast mile 202 366 7041. Electronic mail to the PHMSA Chief Counsel of the Gov. The Chief Counsel operating the administrator of the issue of the emergency order. If the position review with the request of the formal hearing chief administrator, the law of the U.S. Department of Transportation Office of the hearing, and 20 the room to the east, 12 to 320 with the 1200 New Jersey Avenue, Southeast Washington, D.C. 20590. With the fast mile 202 366 7536. There shall be made personally with the commercial delivery service by the electronic means with the consistent and incentive of the breeding of the party of the service they accept. The otherwise provided here in the emergency order shall state with the related relevant service requirements. The list of the person who serves the name the update with the necessary emergency order of their shelf to publish in the Federal Register as soon as the practical authorization certificate of the service each of the order pleading of the motion for the service of the other document shall be accompanied with the certificate service specifying the manner in which the day of the which the service was made. The emergency order shall be served by the hand delivered unless the solicitor for the delivery not practical with the electronic means with the consent of the breeding of the party to be served with the of the personnel with duly authorized the representative of the agent of the services organization president of the constitution of the services bound with the response upon that person. Alright, the report and recommendation administrative law judge shall issue the report recommendation that the close of the record of the board the recommendation shall contain the finding of the fact of the conclusion law of the ground of the decision board based on the material issue the fact of the law presented with the record will be served with the power of the proceeding be issued no later than no material than no later than 25 days after the proceeding the position review the chief safety officer expiration order. If the chief safety officer administrative law judge was appropriate have not disputed the petition for the review within 30 days of the receipt of the emergency order, there shall be it ceases the effect of it unless the administrator issuing the emergency order determines written determining whether the amendment have to provide the basis of the emergency order constitute the existing requirements of the such of the extension shall remain in full force, affecting pending decision on the petition reviewed unless stated or modified the administrative reconsideration. A party agrees with the administrative law judge report with the recommendation may file the petition reconsideration to the safety officer within 1 calendar day. With the report with the recommendation the opposing party may file a response with the petition with the 1 calendar day for the service of the petition reconsideration. Chief safety officer shall review the final agency decision within 3 calendar days. The service of the final pleading no later than 30 days after the receipt of the original petition. The chief safety officer's decision with the merits of the petition of the reconsideration constitutes final agency action. Or the appealated review of the person aggravated with the final agency may with the petition review the final decision appropriate court of the appeal of the United States to provide within Title 49 U.S. Standard Code Fair by 127. Following with the petition of the review that does not satisfy stay with the modified the force of effort of force and effect of the final agency. Alright, the time. The incompeting any of the prior period of time prescribed by the part of any of the order issued the administrative law of the day of the filing of the petition review any of the actions of the event of the default of the waste of the damage designed with the designated period of the time may be ruined, may be run should be not included the last day of the period with the computed shall be included unless the Saturday and Sunday federal holidays in which the event period runs until the end of the next day of the not one of the affirmation days. 109.21 remedies generally. An administrator may request the Attorney General to bring the action of the appropriate United States District Court seeking a temporary permanent injunction for the relief punitive damage assessment with the civil penalties provided in Title 49 U.S. Standard Code 522A with any other appropriate relief to enforce federal hazard material transportation law regulation order special permanent approval to prescribe issued under the federal hazard material transportation law. So Part D, equipment. 109.25 the equipment agency exercise of authority. So Part B with this part of the agent shall the appropriate safety of the handling of the other equipment authorize his or her operating administrator of the equipment requirements of the hazard material inspectors and investigators. Alright, subpart E, prohibition of the hazard material operation and non-payment of penalties. Prohibition of hazard material by operation of the definite hazard material by operation of the prohibition of the hazard material by operation may activate the regulator of the hazard material transportation law of the subchapter C of the chapter exemption of the special permanent approval of the regulated registration if the subchapter owner of the subchapter C of the chapter of the failure to pay the civil penalty full response of the failed to pay the hazard material civil penalty following full 90 days with half days specified payment of the order the pipeline hazard material safety administration the pay federal aviation administration federal motor carrier safety administration federal mayor administration prohibited the conducting hazard material operation shall immediately cease all the hazard material operation beginning on the next day of the 91st of the prohibition shall continue until the payment has been made in full. The discretion of the agency issuing the order, an acceptable payment plan has been arranged. Civil penalties, paid installation, installments. One case basis, the respondent may be allowed to pay civil penalty pursuant to the payment plan of the which was made considered the installment. The payment the respondent failed to make, and the installment of the payment contained within the payment plan was agreed upon. The schedule of the payment plan shall be null voided in full and outstanding. The balance of the civil penalty shall be payable immediately. Respondent that failed to pay the full and outstanding balance of the civil penalty within 90 days after the day of the missed installment of the payment shall be prohibited from conducting hazardous material operations beginning with the next day of the 91st. The prohibition shall continue until the payment of the outstanding balance of the civil penalty has made in the full, including the incurred interest until the discretion of the agency order of the another acceptable payment plan has been arranged. Appeal to the federal court if the respondent appeal to the agency order of the issue, the pursuant of the 109, 103, statute 109, 103, the federal court, the circuit court of the appeal determined payment due for the order of the are not stated unless the court specified applicability of the ticketing section does not apply to the respondent who failed to pay a civil penalty assessed by the tissue issued pursuant to the statute 107 and 310 the subchapter. Applicability to debtor section does not apply to the respondent who is unable to pay civil penalty because the respondent of the debtor for this case under the chapter 11 entitled 11 and let's go to a respondent who is debtor for the case under chapter 11 entitled 11 the USA code must provide following information for the agency decision maker identified with the original agency order as his certificate of service chapter of the bankruptcy code under the bankruptcy proceedings filed the bankruptcy case number of the court in which the bankruptcy proceeding was filed any other information requested the agency to determine the debtor's bankruptcy status penalties prohibited the hazard of the material operation respond with the continued conduct of the hazard material operation violation of the section may be subject to additional penalties including criminal prosecution pursuant to Title 49 U.S. Standard Code 5124. All right, 109.3. 109.103. Note the non-payment of the penalties. If the full payment of civil penalty, the installment of the payment is the agreed with the payment plan has been made in 45 days after the date specified the payment plan final with the agency or the agency may issue since cessation has material operation or to the respondent. The cessation has material operation order issued under this section shall include the filing of information situation, statutory provision, regulation respondent with the respondent violated the term of the may order the agreement with the requirement of the payment the same that indicated the full respondent failed to pay the full outstanding balance of the civil penalty within 90 days after the payment due, the respondent shall be prohibited from conducting any activity regulation that's under the federal hazard of the material transportation law with the subchapter C, the chapter of the exemption of the special permit, the proof of the registration issued under the subchapter C, the chapter the statement describing the respondent option of the responding to the order, which including the option of the appeal of the reconsideration cessation operation order within 20 days of the receipt of the order, description of the manner of the respondent can make the payment of any money due to the United States the result of the proceeding of the full outstanding balance of the civil penalty. The station hazardous material operations over the delivered personal services unless the such service is impossible and impracticable. Personal service is impossible and impracticable. The service may be made with the service may have the commercial express services respond principal place of the business of the foreign country. It will be delivered to the respondent's designated agent as prepared in accordance with the statute 10540 of the subchapter. 110 has material public sector training and planning grants.